Today's webinar is entitled Operational Impacts Posed by Bill 64. And our guest speaker is Charles Morgan, a lawyer and partner with McCarthy Tétrault. We have Janet Schulist from the Quebec Branch, who will be introducing today's guest speaker. Janet?
Thank you, Claire. Good afternoon, everyone, and welcome. We're very pleased as a Quebec Branch to have Charles Morgan with us today. Charles is the national co-leader of McCarthy Tétrault's cyber data group and a former leader of their technology law group. He is the former president of the International Technology Lawyers Association and is recognized as a thought leader on the responsible development of artificial intelligence. Charles regularly serves as a breach coach for clients in matters of enterprise-wide risk, including on 3 of the largest cyber incidents in Canada's history. Charles's practice is focused on advising some of McCarthy's largest clients on their most complex commercial transactions involving IT outsourcing, systems integration, cloud, financial technologies, data security, artificial intelligence, privacy, licensing, e-commerce, and telecommunications. As one of Charles's clients, I am sure that today's presentation will not only be thought-provoking, but will also provide clarity on many aspects of Bill 64 and its implications for your business today and in the future. So thank you, Charles, for joining us, and I will hand it over to you.
Thank you very much. Delighted to be here today with the Institute. I'm going to be focusing on, discussing the operational impacts of Quebec's Bill 64. And I think probably most of the people on the call will be Quebec-based, but not everybody. And that's a good thing, because Quebec's Bill 64 is a precursor. Well, first of all, many companies operate nationally. And so even if you're sort of based in another province, you may well have a Quebec presence. But the other reason for people from outside the province to sit in on today's session is that Bill 64 can be seen as a precursor to what we can expect will ultimately apply in the context of law reform efforts in the privacy space right across Canada. And there's a reason for that. Canada is currently a country that has obtained a favorable adequacy decision from European authorities in relation to transfers of data from Europe to Canada. In other words, the European authorities consider that Canada's data protection regimes offer appropriate and adequate protection to the data of European data subjects. And that adequacy assessment was established prior to the adoption in Europe of GDPR, the General Data Protection Regulation. But it's expected that if Canada didn't change its laws on the privacy front, in order to become more aligned with EU's GDPR, we would not maintain our current adequacy status. And that would make transfers of data from Europe to Canada much more complex. And so one of the reasons that Canada is updating its privacy laws, but is to ensure that when Europe again assesses our laws, they will be deemed to be adequate. And Quebec has been first out of the gate on this, and Bill 64 implements sort of European-style data protection obligations and sanctions. But we can expect that something quite similar will happen federally and perhaps in other provinces. Already federally, just prior to the previous federal election, there was Bill C-11 that went through various phases of the parliamentary adoption process. It was not adopted before the election, and so died on the order paper. But we can expect a version of C-11 to come into force, or to be represented shortly, and it may well look something quite like Bill 64. So the discussion today is really about data governance. Bill 64 imposes a whole range of new privacy-related obligations. And businesses these days are collecting, as you all know, a vast amount of data and are using that data in ways that are adding a great deal of value to their businesses. But it's also, you're all realizing with, in the age of hackers and nasty, cyber threats, that data is a source of risk. And so risk and value at an entire enterprise-wide level that must be managed through appropriate governance. So the presentation today is going to cover three things. First, I'm going to give you an overview of the new regulatory obligations under Bill 64. Second, I'm going to give you a bit of a checklist for what can be considered mature evidence of a mature data governance regime within your company. And then I'm going to, at the end, if we have time, I'll touch on this movement beyond mere compliance. And I want to talk a little bit about ethical AI governance, because as many of you may know, data is the fuel of artificial intelligence. And when you start to think about using AI systems to process data and derive insights, there's an added layer of governance concerns that have to be considered. It's not just privacy compliance. There's a broader range of issues that arise. And I want to flag those because they're starting to present themselves, not just from a principled perspective, but they're being reflected in actually the regulators' guidance to the market. So we'll touch on that at the end of the presentation. So first, regulatory compliance. I want to start with an overview of Bill 64. And whenever a lawyer talks about new laws, the first thing that we do is try to put the fear of God into our listeners by talking about the sanctions in terms of in case of non-compliance. And the first thing to note is that whereas in the past, privacy laws in Canada were more or less on the basis of the name and shame regime. In other words, if you did not comply with Canada's privacy laws, well, you might have gotten a bad reputation in the sense that there could have been some articles published in the newspaper about you. You could have had an unfavorable decision from the privacy commissioner. In some cases, there could be, for the most serious events, there could be a class action brought against you. And we have seen a number of those and a growing trend towards those, but there weren't significant administrative monetary sanctions for non-compliance. That world has changed massively. So we've gone from 0 to 100 miles an hour. Bill 64, which has been adopted, but is not yet fully enforced, proposes administrative monetary penalties of up to $25 million or 4% of worldwide revenue. These are huge amounts. For some companies, that could be sanctions, potential sanctions in the billions of dollars. And so obviously the whole risk reward calculus associated with compliance around data protection has been shifted entirely. So the timeline for coming into force, as I mentioned, Bill 64 has been adopted. Bill 64 is the act to modernize Quebec's existing privacy regime, and it received royal assent September 22nd, 2021. Some of the provisions are going to start to take effect as of September of this year. So it's important to know what those are, is because you really have to get on with it in terms of meeting those obligations. The vast majority of the obligations will take effect September of 2023, and the data portability obligations will take effect September 2024. Two things that are important to retain here from this slide. the obligations taking effect September 2022 relate to the mandatory breach notification obligation. So in the event of an incident, you have to, a cyber incident, you have to have a breach or incident registry, a register in place. And if the incident results in a risk of serious injury to the individuals concerned, then you're going to have to notify the Privacy Commissioner, the Commission d'accès à l'information. Those obligations are similar to existing obligations that are already in place if you're subject to PIPEDA federally or to the Alberta Privacy Act. And so many companies will be already largely ready from a compliance perspective with those obligations. In addition, and I'll get to some nuances because there are some differences between the Quebec requirements and the requirements under other privacy laws in Canada that are important to note. But the other provision before I get there that takes effect in September of this year is this obligation to appoint a person in charge of protecting personal information for your company. By default, it's the person, it's like your CEO, the person who has the highest level of authority in your organization. But you can delegate that authority to, for instance, a chief privacy officer. As of September 22nd, 2023, the vast majority of the other sections of the law will come into force. Those include provisions related to conducting privacy impact assessments. They relate to a whole host of new transparency obligations that you'll have. They relate to performing an adequacy assessment of the laws of the jurisdictions in which you are hosting your data, and a variety of provisions that include new provisions related to automated and restrictions on automated decision-making using personal information. And then finally, in September 2024, there's a right of data portability will take effect, and we'll get to more to that in a moment. So starting off, it's important to understand that this notion of accountability is at the core of the privacy legislation. It's the first principle of PIPEDA as well. So that in itself won't be entirely new for those who've been functioning in compliance with PIPEDA for a long time. But it gets much more granular in the Quebec Act, and it requires a lot of thought around appropriate data governance. So as I mentioned, the first obligation is to appoint a chief privacy officer. By default, the person exercising the highest authority within the enterprise will be responsible for all uses of personal information and a whole host of information governance obligations that we'll talk about. But as I say, the Bill 64 also requires enterprises to adopt governance rules for protection of personal information, including a specific framework for the keeping and destruction of personal information, and definitions of roles and responsibilities for personnel involved, and processes for dealing with complaints. And information regarding those policies and practices must be published in simple and clear language on the enterprise's internet site. So you have to be transparent about your governance processes. And that's new. Next item is this, I'm touching first on the obligations that are going to take effect immediately or almost immediately September this year. So there's this incident registration or incident registry or register requirement. So you'll see in a moment the breach notification obligation, the obligation to notify a privacy commissioner or the individuals affected by a security incident is subject to a threshold test that you have to notify where there's a risk of serious injury. And we'll get more to that in a moment. But the incident register obligation applies to any confidentiality incident that occurs, whether or not that incident it involves a risk of serious injury. So what that means is that organizations are going to have to put in place a register that tracks every confidentiality incident, every incident involving unauthorized access, use, or disclosure of personal information. And in some instances, you'll have to provide a copy of that register to the Commission d'accès à l'information and or notify the commission of the incident and or notify the individuals affected of the incident. What that means from a data governance perspective is that it's very important to think about how you're going to put in place that incident registry, because you have to capture all of the information that's required by law in that registry, but you don't want to have a registry that's designed in a way that basically it's going to become Exhibit A in the class action that's brought against your company, that's saying all the terrible things that you've done or haven't done to protect people's information. So the information has to be presented factually, accurately, completely, but it shouldn't be presented in a way that's completely raw, that hasn't been thought through in terms of how people are capturing the information. And you're going to need to have your legal compliance or privacy department assessing how that information is captured and expressed, and when and whether it's necessary to make a breach notification to the commissioner or to individuals concerned. And you'll see there's although the Bill 64 language is similar to language found in PIPEDA and in GDPR, there are some slight differences that would suggest that this obligation is even broader in Quebec than it is elsewhere. Similarly, the breach notification requirement, whereas the threshold test under PIPEDA that you may well be familiar with already is that you have to notify of a breach in the event of a real risk of significant harm, the Roche test. The test under Quebec law is similar but slightly different. It's whether there is a risk of serious injury. And so it's not a real risk, it's a risk. And unfortunately, it's not clear yet whether that is a distinction with a difference or whether that's a distinction without a difference. It may mean that they mean essentially the same thing. Also, unfortunately, whereas PIPEDA has a sort of a statutory definition of what is meant by significant harm, Bill 64 does not currently have a definition of what is meant by serious injury. So there's a level of uncertainty there that may be resolved by regulation or decisions by the commissioner or guidance by the commissioner. One thing to note is that whereas GDPR has a 72-hour breach notification timeline, under Bill 64, like PIPEDA, it's sort of a malleable term, as soon as is practicable, which is sort of similar to as soon as feasible, which is the timeline under PIPEDA. Also important to note that in the event of a breach, there's this obligation not only to notify in certain circumstances, but also to take reasonable measures to reduce the risk of injury and to prevent new incidents of the same nature from happening. So this is an and obligation. It's not an or obligation. And it's it applies to all confidentiality incidents, even those that might not result in a risk of serious injury. And what that means is you're going to have to act, and you're going to have to demonstrate the fact that you've acted. You've done things to help ensure that you will be able to prevent new incidents and that you have taken measures to reduce the risk of injury. So that requires a paper trail, and it requires actual action. Now, the next item is that's new on the plate. This is something that would be familiar for those of you who've worked to ensure compliance with GDPR. But it may be entirely new for those of you who are, simply been subject to PIPEDA or the former Quebec regime. And that's the obligation to conduct a privacy impact assessment. So there are two specific circumstances under which, under Bill 64, companies are going to be required to conduct a privacy impact assessment. And the first is where you, anytime that you commence a project related to the acquisition, development, and redesign of an information system or electronic service delivery project that involves the collection, use, communication, keeping, or destruction of personal information. So if you're designing and implementing a new information system that treats personal information, that processes personal information in some way, or if you're upgrading in a material way an existing system, then before you do that, you're going to have to conduct a privacy impact assessment. So this is something that, again, is going to require a process. It's going to require documentation. It's going to require people who are accountable for managing this process. And it's going to be a process that's going to involve both your sort of compliance function and the business unit, those who are involved, maybe IT that's implementing the information system, maybe a business unit that has decided that this information is required, but compliance is also going to have to be involved in order to ensure that this privacy impact assessment has occurred. Secondly, a privacy impact assessment must also be conducted anytime an enterprise communicates personal information outside of Quebec. Now, this isn't just when you communicate it outside of Canada. It's literally when you communicate personal information outside of the province of Quebec. So a Quebec to Ontario transfer would also be subject to this requirement. And what it says is that before communicating personal information outside Quebec, a person carrying on an enterprise must conduct an impact assessment that addresses the following factors: the sensitivity of the personal information in question, the purposes for which it'll be used, the protection measures, including contractual ones that would apply to it, and the legal framework applicable in the jurisdiction to which the personal information is being transferred. So whereas the GDPR, that adequacy assessment is in a sense performed by the regulator, under the Quebec Act, that adequacy assessment has to be conducted by the enterprise itself, which is quite a remarkable undertaking. And a lot of organizations are simply not equipped or qualified to conduct that kind of adequacy assessment, and we'll have to rely on outside counsel in order to do that. And once you've conducted that impact assessment, well then, in the case of cross-border data transfers, you also have to enter into a written agreement that is designed, a contractual agreement that is designed to ensure that the information will receive an adequate level of protection, even when it's been transferred outside of the province. And we'll have to understand, it'll take some time before we get a full view as to what sorts of measures are going to ensure that the information will receive adequate protection measures. But the Bill 64 provides this guidance, section 18.3, is that the mandate or contract for services must take into account measures to protect the confidentiality of the personal information communicated, ensure that information is used only for carrying out the mandate or performing of the services contract, and that the mandatory or person performing the services do not keep information after the expiry of the contract for services or the mandate. And so vendor management, in other words, is going to become a core component of your data governance obligations going forward. Next item is that there are new provisions related to automated decision-making. And so there's There's increased anxiety, let's put it that way, about the fact that machines are making decisions that have an impact on our lives, in particular, machine learning and artificial intelligence. The way this issue is addressed in Bill 64 is that any person carrying on an enterprise who uses personal information to render a decision based exclusively on automated processing must inform the person concerned of the fact that they're using an automated decision-making system. And also, at the latter's request, must tell the person what personal information was used to render that decision, the reasons and principal factors and parameters that led to the decision, and the right of the person concerned to have the personal used to render that decision corrected. In a sense, it's a mix of transparency obligations, just letting people know that an AI system or an automated decision-making system is being used, and an explainability obligation, helping people understand how the decision that it impacts them came to be. And so this would apply, for instance, somebody applies for credit, or somebody applies, anytime where there's a sort of an application process and you can be accepted or declined, and that decision is going to have an impact on, in a sense, your legal rights. If that decision is being taken exclusively by an automated processing mechanism without the intervention of a human, then these provisions would apply. So that's the regulatory backdrop under Bill 64. There's a lot there, and I think you've probably got a sense of it. And terrifying, as I say at the outset, that non-compliance with these new obligations can result in, administrative monetary penalties of up to $25 million, or 4% of worldwide revenue. Clearly, you'll have understood that compliance with the bulk of these obligations is going to have an impact on how you run your business, how you collect data, your IT systems, and how they are structured, and your governance processes internally. And so before going further and taking questions, I want to sort of run quickly through a bit of a checklist on some elements that you consider as part of a mature governance program. So the first thing to note is, the data world has changed. If there are these incredible things that you can see on the internet about looking at stock market cap values of the largest companies in the world, and before, they were oil companies, or they were banks, or they were car manufacturers, or things like that. Now, most of them are data companies, and this move towards the value of data and deriving valuable insights from data is only increasing. And you can see this, JP Morgan indicating that the metaverse will represent, shortly $1 trillion a year opportunity. And the other factor in terms of trends is that data borders are thickening. We saw that with the cross-border data transfer provisions in Quebec's Bill 64. And we saw that already with GDPR, data adequacy decision regimes. And the cost of non-compliance is increasing, and therefore the risk-reward calculus has been fundamentally altered. Therefore, all of that to say, get data governance, proper data governance, is not something just for specialists. It's not, this is not a matter for just the IT department or just compliance. It's a matter of enterprise-wide risk, and it has to be understood by the board of your company that is the case. So from a data governance perspective, a few things, and I'll move quickly through this. You have to be able to demonstrate board engagement. This is a board level issue, and you have to be able to establish a paper trail that you're treating this as such. Your chief privacy officer has to be provided with sufficient authority to ensure that privacy risks are managed and mitigation measures are in place. Your chief information security officer, if you have one, has to be given sufficient hierarchical position and budget to manage internal and external IT risks and help prevent incidents. And ideally, best practice is that you have 3 lines of defense on these measures. Now, this concept of three lines of defense will be very familiar, for instance, to those of you in the financial services industry. But you've got the business lines, you've got the legal compliance, regulatory line, and you have the audit line. So the business line, they're the frontline people who are implementing the policies that data governance and privacy and cybersecurity policies that are put in place by the compliance function. And then your audit function is actually telling you, well, we do this, we reviewed this and we do what we say and we say what we do, which is always core. This internal governance in process, if you're going to do this properly, always is going to start with some form of data inventory and data mapping. You have to know what kind of data you have, how it's being used, where it's being stored, to whom are you transferring it, who are your service providers that are storing it and processing it, for what purposes are you using it, and you have to have some form of privacy and security by design implementation plan. You need to provide adequate training for your employees and be able to demonstrate that you provide that training related to privacy, information security, and regulatory compliance. And it's always good to have a code of ethics in place that may well include these days, and this is a new feature, AI or data ethics committee. We're seeing some of our most sophisticated clients introducing the notion of a data ethics committee. That's from the governance perspective, internal governance. What kinds of policies and procedures do you need to have in place? Well, there's a whole set. You need your external and internal privacy policies. Ideally, you'd have a RACI matrix or other documentation related to privacy rules and responsibilities. You'd be able to point to a privacy program strategy or other documentation that outlines from an overall perspective, what your privacy framework is. You have to have, as I've discussed, a privacy impact assessment template and process and criteria, and a privacy risk assessment or methodology associated with that, so that you understand when and where a privacy impact assessment must be performed. Vendor management is going to be key. I mentioned OSFI B10. That will be a document that's familiar to any of you who are in the financial services industry, but that notion of vendor management comes directly from Bill 64 and even existing by PITA. That notion that you'll have to conduct adequacy assessment processes for cross-border data transfers that I've already discussed. You'll have to conduct privacy impact assessments, and you'll need standard controls over data location, subcontracting, breach notification, privacy and IT security, and cyber insurance. So take a look at your standard contracts with your vendors. Do they contain these kinds of provisions? And if they don't, then it's time to update them. It's time to upgrade them and improve your data governance processes. IT systems and security. Well, this is an ongoing and frankly costly process. The hackers and threat actors are nasty people. They're very bright, very good at what they're doing. They're making a lot of money, so they can invest in getting very good at what they're doing, and even better in identifying new vulnerabilities, including via phishing. Ransomware has just grown exponentially. So you need internal security policies and guidelines on data classification, so that you can identify, your crown jewels, your particularly confidential, highly sensitive, or non-sensitive data. Establish acceptable use policies. Map out the data flows and lists of IT systems, tools, and applications, so that you actually have a data inventory of those systems and the data categories, and attribute clear ownership with regards to each existing and new system. implement best practice security measures like multi-factor authentication, encryption of data at rest and in transit where appropriate, and consider adherence to information, recognized information security measures such as ISO 27001 that applies to data centers. And then think, and this is going to have an impact on how your data systems, information systems are structured, about data right obligations. Individuals increasingly are going to have increased control over their data. They're going to be able to indicate that they want to have access to their data, all data that you hold about them, all personal information that you hold about them. They might try to exercise a right of data erasure or data portability. These are new rights under Bill 64. And in general, you'll have to be able to demonstrate that you're only retaining data for so long as necessary to fulfill the original purpose of collection, which means that you have to have processes that will responsibly result in the deletion of data that is no longer justifiably held. From a marketing perspective, well, you've got your lists of marketing methods, and of course, you still have to comply with CASL if you weren't sure that your life was complicated enough. And depending on whether you're in a regulated industry, there's all kinds of controls around how you market using the data that you have on hand. And of course, finally, you can't forget HR and your employees, because this applies not only to your customer personal information, but to employee personal information. And you want to think about how these issues are addressed in the employee context, including policies, clear policies on employee monitoring. And then finally, we've got the breach response readiness. Do you have an incident response plan in place? Have you prepared that breach registry that I talked about at the outset? Have you a methodology that is designed to help determine whether there is an incident might result in a real risk of significant harm or a risk of serious injury, as the tests are? And KPIs, ideally, for tracking breach response performance. How long does it take you to respond to an incident that's been notified to you, and so on? So there's a lot here. Information governance, you've got your hands full, and I don't want to minimize this. There's some time, as I say, Bill 64 takes effect over the course of 3 years. A number of the provisions, most of the provisions take effect not this September, but next September. But as you can appreciate, if you're going to hope to be compliant by in time for the September 2023 provisions taking effect, you really have to start that process now. So it's incredibly important that you have the right team and the right resources, and obviously McCarthy's and others are there to help. On the cybersecurity risk management front, I just wanted to point to McCarthy's publication that may be helpful. We've published a huge number of blogs on Bill 64, so those resources are also available to you through our website. But I want to just quickly, before we turn it over to questions, I wanted to address a topic that is of particular interest to me, and I hope of particular interest to at least some of you, and that is the topic of ethical AI governance. And Janet mentioned at the outset that I was recently, for a couple of years, the president of the International Technology Lawyers Association. And while I was president of iTechLaw, I led a process to draft a book on the responsible deployment of artificial intelligence. It's called Responsible AI. It was written by 54 lawyers from over 20 jurisdictions around the world. And it's based on a series of core principles about ethical AI. And if it's not the case already, it's probably going to be the case soon, that as you look to use the data and process the data that you have on hand to derive valuable insights, to bring value to your customers and to your business, that processing using increasingly sophisticated automated tools based on machine learning and artificial intelligence are going to start to raise some ethical issues for you. And so the point that I want to make here is that what we're seeing is that we're moving beyond mere privacy concerns to a range of broader issues. And I'll point you to our book, which is available online. And we originally published the book Responsible AI in 2019. We then did an update in 2021. And that update includes a responsible AI impact assessment, a template that's available if you're interested. But I wanted to point to the fact that we're now starting to see a movement towards actual regulation in this space. And we move from principles to regulatory guidelines to actual regulation. And the actual regulation, I've already mentioned the fact that there's these rules under Bill 64 that will take effect related to automated decision-making. But here, let me just point to core principles that were included in a recent report published by the AMF, the Autorité des marchés financiers, that regulates the financial services industry in Quebec. And they talk about principles that have to be considered when deploying artificial intelligence systems. And they include that notion of transparency and explainability that I already talked about when we talked about what are the requirements under Bill 64 related to automated decision making. They include a notion of accountability. This is not just your IT department that's going to deploy an AI system. You really need to think through these issues. And so in the same way that you're going to conduct, that somebody's going to be accountable for this, and it's going to be your organization if you're deploying it. And therefore, you should conduct an impact assessment before deploying to identify risks and to try to mitigate those risks. Other issues beyond privacy unfold, and they include fairness and non-discrimination. We see there's been all kinds of cases where, if the quality of the data, for instance, has not been verified, then bias that exists in the underlying data will simply be reflected and perhaps even expanded. I'm missing that word, but anyway, accentuated in the automated decision process. So there's all kinds of scenarios where AI systems have been used for probation purposes and in assessing a probation risk in the United States. And populations like the black males are in a discriminatory way held by the system to pose an unreasonable level of risk, and therefore they're refused access. Or certain populations are refused access to credit. Women, for instance, may not have had opportunities to develop a credit profile based on previous buying experience, and therefore are refused access to credit based on the fact that there's less data available. We have to look at those scenarios very carefully to make sure that you're not engaging in unfair or discriminatory processes. And this notion of solidarity and economic solidarity and security. So there's a range of new issues that are coming to the fore, and they have to be thought through carefully. These are principles that are identified by the AMF. Our Responsible AI book includes 9 principles. This is the book itself. Both of these are available on the internet and through our website. But what it means, again, from an information governance perspective on ethical AI is that same sorts of principles. There's the internal governance that you have to think through with the audits and with the impact assessments and training and robust incident and response management. There's the vendor management, there's the supplier management, there's client relations, to ensure that you're getting feedback to redress through the loop and through the cycle of use of that AI system. And then there's the compliance need requirements that you'll have to face under Bill 64 and eventually under C11 or the successor legislation to that when it comes in play. So I'll point to finally to these other non-binding frameworks that exist, including the Montreal Declaration for Responsible AI Development, and some other helpful guidelines. And I think I shall stop there and take any questions that you may have. And I realize I haven't checked the chat box, so let me just take a look at the chat messages. Okay, so that's simply information, but I don't see any questions at this time.
I don't see any questions as of yet either, Charles. Oh, there's one here. Could we expect annual board declarations under Bill 64 similar to the ones for AMF?
So it's not a legal requirement. In other words, there's not a specific obligation for boards to make sort of a Bill 64 declaration. But as I said, that accountability principle is core to Bill 64, and so being able to demonstrate the accountability of your organization is going to require board intervention. And that you'll want to be able to demonstrate that, for instance, in the event of a security incident that it involves material risk to your company, that incident has been reported to the board, that the board has taken measures to address that incident, that remediation measures and measures designed to ensure that the incident does not recur have been taken. That the board is ultimately doing things like approving a budget that is appropriate for the level of risk for the organization to the CISO and on the information governance perspective, that the board is appointing as a chief privacy officer. So all of these things are going to require board level attention, and that will have to be reflected in board minutes.
Are there any other questions for Charles? Let's see. Nothing
Okay.
yet.
Oh, wait a minute. There we go. Not for profit corporations under the same rules. It's a good question. Do you mind? I don't want to misstate myself, so I'll let me send a response to that afterwards. PIPEDA applies to commercial activities. I'm not sure that there is a similar provision under the Quebec Act. So let me refer back to that.
Anything else? I don't see any. Nope, new one. It doesn't look like the requirements.
No. Yes, no. Clearly, the obligations are not limited to listed or public companies only. This applies to the entire private sector, and by the way, there are also sort of analogous sets of rules that are applicable to public sector entities in Quebec as well. So Bill 64 also amended the Public Sector Act as well as the Private Sector Act. Well, maybe if there are no more questions, that might mean I can go down and get a sandwich. I think. I think that one of the takeaways, obviously, is we have a terrific team that has been helping our clients go through a compliance process is structured. We've got a standard service offering that starts with the information gathering process that performs a full data inventory of the data that you're collecting and assessing how you're using it, an examination of your current state level of maturity, to put it in those terms. And then we move to a second phase, gap assessment. What are you doing versus what are the obligations? What's the gap? We develop with our clients a roadmap for compliance, and then we help our clients right through with the implementation of those remediation compliance efforts. And we can do that with the support of MT3, which is, it's almost like a consulting wing of McCarthy's that started as an e-discovery operation, but has evolved into a full information governance repository of a center of excellence for our team. And we've had the opportunity of working with, a huge number of clients on these matters over the last many months, and we'd be delighted to help with any of you. I am seeing the comment about the burden for SMEs, and it's true. It's some of these times, these laws and regulations, sometimes they're drafted with a certain prototype in mind, and I think in this case it's like people who are thinking about Facebook and Google and Amazon, and they're thinking about corporations that have huge budgets that may be using personal information in ways that have a pretty significant impact on society, and so that the range of obligations and the level of sanctioning power that has been put in place are very high. And so I think everyone's conscious of the weight of the burden on SMEs in this space, and I think that we can only hope that the regulator will also take into account the resources that small, medium-sized businesses have. The good news is that in many cases they also have less data to process, and less complex hierarchies and less complex vendor relations. But there's no question that this is going to require a lot of many businesses, and that's one of the reasons that we've tried to when we're helping our clients to kind of go through a very structured process that we can continue to roll out in an efficient way, so that clients can do some of this. We have tools that can help clients help themselves, if you will.
Janet, did you have a question?
I did have a question. So it is very burdensome. So my question is, is there any, or do you think that the development will be that maybe the stock markets request, some kind of annual declaration about it to begin with, or that the regulators will ask companies to sign off and prove that they have all this in place? I mean, I'm just curious as to how they're going to actually regulate it for the everyday medium-sized business who may not be public or may be public.
Yeah. Well, so I mean, a few things. First, as somebody pointed out earlier, this law it doesn't just apply to listed or public companies. So it applies to everybody. Public companies are going to have to make disclosures that are going to be clearly, more involved than privately held companies. Privately held companies still are there's the governance, their ability to demonstrate their compliance with these governance obligations will still have to be present in some quite concrete ways. What the law says is you have to publish on your website, even private companies, information about your privacy framework, about your overall approach to managing compliance, and about how the roles and responsibilities have been allocated, and how people, your complaints process. So that's a public obligation through your website. Also, you have to have this incident register of confidentiality incidents. And the Bill 64 clearly says that you may have to provide, upon request, a copy of that register to the Commission d'Accès à l'Information. The Commission will have the ability to come in and see whether you have conducted privacy impact assessments and done these things. So as I say, it's not enough to do it. You have to show that you've done it. And whether you're a small enterprise or a publicly listed enterprise, that those facts hold. There's a question about whether this may trigger some sort of exodus from Montreal, Quebec. This is an ongoing issue on any number of fronts. I mean, we're even seeing it with Bill 96 and the French language laws, and the rules about contests that are a little bit more complicated in Quebec than elsewhere. What I would say, yes, these laws are definitely more burdensome right now in Quebec than they are in the rest of Canada. However, as I said at the outset, I think it's fair. The chances are good that federally and in other provinces across Canada, we're going to end up having legislation that is quite similar to Bill 64, because Canada wants to maintain its adequacy status vis-a-vis Europe, and because there's a broad public clamoring for increased privacy protection from the public that's popular with governments. C11 was generally supported even by the opposition parties. And so I don't think there's going to be a lot of resistance when some sort of, what is it? Not a precursor, but anyway, subsequent version of C11 is presented before Parliament. And so on that front, it won't be a situation where life is a regulatory burden and miserable in Quebec, and it's simple in the rest of Canada. What we really hope to see is that there's a level of harmonization across Canada in this space, and so that companies carrying on business can know that if they comply with one set of privacy laws, they're really complying with the privacy laws right across the board. And so when we've been helping our clients, think through that process and think through, some of our clients have an international presence. Some of them are conducting business in the United States. California CCPA has already been in force and it's already been amended. There are now 5 states that have introduced privacy legislation of general application. And that's totally new for the United States. It used to be kind of cowboyish in the United States in terms of how you could use personal information. That world is changing. And I think we're going to see that world is changing, not just in Quebec, but right across the country. GDPR, European GDPR was the precursor, and it's become something of a worldwide de facto standard. So I think it's fair to suspect that these issues are not going away. And that information governance, privacy, compliance are just going to be a part of carrying on business for businesses right across Canada and around the world.